Hi, welcome to the Labor Guild's Conversation Corner. I am Lisa Field, president of the Labor Guild, and I am pleased to introduce Dan Fogarty for today's conversation. Dan is a partner at Sandulli-Grace, PC, where his practice focuses on representing unions and their members in a wide range of labor matters. Dan is one of our beloved instructors at our School of Labor Management Relations. Thanks, Dan, for joining me. We wanted to talk about the Supreme Court case Starbucks versus McKinney. But before we get into the case, Dan, if you could give a little overview about the National Labor Relations Board, or NRLB, boy, is that a mouthful, NLRB, as the authority of this federal agency is at the core of this case.
Yes, of course. Thank you, Lisa, for having me. I thoroughly enjoy all of the times I get to interact with the Guild. It's some of the best part of my work, so I'm really glad that I'm able to do this tonight. So the National Labor Relations Board, or the NLRB, is an independent federal agency that was created by Congress in 1935 to enforce a law called the National Labor Relations Act. Some of the NLRB's primary objectives are to protect employees' rights to organize, join, or assist a union, to bargain collectively with their employers, and to engage in other concerted activity, which can include a range of things, but typically it's employees' rights to work together to improve their working conditions, like their pay, their leave time, procedures around discipline, and worker safety. To enforce the act, the NLRB will process unfair labor practice charges, which are often referred to as ULPs, that are filed by employees or by unions alleging that an employer had violated the law. The NLRB staff investigates those claims and may issue a complaint against the employer if they find that the employer may have broken the law. The NLRB will then prosecute the ULPs against the employer in an administrative proceeding within the NLRB, first before an administrative law judge who can issue a binding decision, but then before the board itself if either party appeals. It's important, especially when we start talking about the case we're here to talk about, to note that the administrative process takes many years in most cases.
Thank you for that. So let's dive into the case. What was the case about?
Yeah, so Starbucks Corporation versus McKinney was a Supreme Court case that was issued in June of 2024, which made it harder for the NLRB to get an injunction on behalf of employees that the board believes were terminated in violation of the law. And so when we think about that, the first question that I think comes to mind is, what the heck is an injunction, right? So in general, a preliminary injunction is a temporary order by a court requiring a party to either do something or to not do something while legal action is ongoing. So an injunction is meant to preserve the relative positions of the parties during litigation. So an example might be if there's a dispute over personal property between two people and someone files a lawsuit, they can seek an injunction and the court may order the party that's in possession of the property to not sell it or to not destroy it, right? You can kind of imagine the bulldozer's about to kind of wreck a piece of property. And if there's litigation over that, a court can order them to stop. In this case, the court's considering a specific kind of injunction that was created by the National Labor Relations Act, and we refer to as a 10J injunction based on the section of the law that it comes from. Section 10J provides that upon issuance of a complaint, the board can petition a federal district court for appropriate temporary relief, and the court may grant that relief if it deems it just and proper. So what this means is that after someone files a ULP, the NLRB, if they issue a complaint in that case, can ask a district court to issue an injunction requiring an employer to temporarily remedy the alleged ULP while the case is being litigated. Here, the Supreme Court considered what the NLRB needs to prove to the district court to have an injunction issued. So the case is against Starbucks, so I'm sure you can imagine it stems from the ongoing organizing campaign that's happening at Starbucks stores across the country. So Workers United began an organizing campaign involving Starbucks sometime around December of 2021. By January of 2022, employees at a Starbucks in Memphis, Tennessee, were interested in organizing their store too. They ultimately sent a letter to Starbucks notifying them of their intent to unionize. So they were being, clear with their employer. We're trying to organize a union at this store. Shortly after sending the letter, several employees, including members of the organizing committee, invited a news crew to the store after hours to talk about the unionization effort. Starbucks ultimately fired several employees for various supposed policy violations that stemmed from that media event, having the news come to the store. And, when you read into it a little bit, I think that there's a lot of discrepancies about what it was to be after hours and whether these policies were actually enforced. That's all going to be litigated as part of the ULP. So the union and the employees believed that Starbucks terminated this group of employees in Memphis in retaliation for their efforts to unionize. The union filed unfair labor practice charges against Starbucks as a result, claiming both that the terminated employees were harmed because they were fired, and that the employer's actions chilled the other employees' union activity by trying to scare them off of the union campaign. After investigating the charge, the NLRB issued a complaint against Starbucks. And after issuing the complaint, the regional director went to federal district court and asked for a 10J injunction to reinstate the fired employees. I think in the media, these employees are often referred to as the Memphis Seven. They were terminated, and the regional director went to court and asked for an injunction that Starbucks be forced to rehire them while the litigation was ongoing. The district court granted that injunction and ordered Starbucks to reinstate the employees. The district court and then the Sixth Circuit Court of Appeals found that the NLRB had met its burden of showing what they called reasonable cause to believe that unfair labor practices occurred and that injunctive relief was just and proper. So according to the court, this standard required the union to show that its legal theory was substantial, as opposed to frivolous, and that an injunction was necessary to restore the status quo and protect the board's remedial power. Again, this comes back to the idea that an injunction is meant to preserve the parties' relative positions. If at the end of this litigation, the board is not able to meaningfully remedy the violation, there's a real concern that the employees, won't have an opportunity to have their rights restored and to be vindicated after being unlawfully terminated. So ultimately, Starbucks didn't like that answer. They appealed that case all the way up to the Supreme Court, and they argued to the court that the district court should have applied a higher standard when considering the board's injunction request.
Now, is that unusual? Let me just while you're stopping there for a minute. Is that an unusual kind of is that a usual kind of defense or from the employer then to be able to appeal? I mean, is that argument, was that unusual or just kind of expected that the employer would say such an argument? I guess that's my question.
Yeah, so I think in general, major corporations appealing these decisions as far as they can is relatively common as a way of trying to kind of attack the union organization effort, right? It costs a lot of money to go through these appeals, and their hope is that they'll get a judge or a group of judges who see it through their lens and kind of put them in a stronger position. So it's not totally unexpected for Starbucks to appeal. And besides that, at least arguably, there was some disagreement among the circuit courts as to how these injunction requests should be processed. The employer asserted that there was what we call a circuit split, that the circuits were handling these issues differently based on what part of the country you were in. The board argued that was more that wasn't a substantive difference, that the courts were generally doing the same things. But ultimately, the Supreme Court distinguished that, I think 4 of the 13 circuits were already applying this higher standard. And so the court felt the need to take this case on appeal to give a final ruling to make sure all of the circuits were handling this the same way.
And one more question before you go on. So it's a legal question. So when these cases are filed in a circuit, as you say, is that you can't pick which circuit it's going to be at? It has to, is there a geographical reason?
Yeah, so
because
for the most part, the Circuit Court of Appeals are all divided up by geographic areas. In Massachusetts here, we're in Circuit 1, the First Circuit, as they would say. And so this in Memphis, Tennessee, they were in the Sixth Circuit. So different parts of the country are covered by different circuit courts. When you're dealing with administrative law, there's some opportunity to kind of pick your forum, but more or less, it's usually like a location thing, a geographical thing.
Got it. Thanks.
So the Supreme Court took up the case, and ultimately, why we're talking about it is they overturned the lower courts, and they ruled in Starbucks' favor. All 9 justices agreed in the judgment, which is, not something that we've come to expect these days. Only Justice Jackson dissented in part, kind of disagreeing with some of the opinion of the court, of the majority. So the Supreme Court decision holds that all district courts must apply the higher burden courts typically use in evaluating other injunction cases, and that the NLRB is not entitled to any difference on its preliminary determinations about a case. So let's talk about what that means a little bit. So the traditional test used to decide whether a court should issue an injunction in other cases is a 4-factor test that requires the plaintiff to clearly show likely success on the merits, likely irreparable harm, meaning something that can't be fixed later, that the balance of equities favors them, and that an injunction is in the public interest. This is an exacting standard. This creates a really high bar for an injunction to be issued. Now, the court's reasoning is based on a presumption. The Supreme Court holds that there's this pre-existing presumption that courts must adhere to this traditional test, this 4-factor test, unless the statute at issue clearly requires another standard to be used in evaluating an injunction request. So then the court looks at the text of the NLRA. They go to Section 10J, and they find that it does not overcome the presumption, and that by using the phrase, by instructing courts to issue relief when it's, quote, just and proper, it's not creating a new standard, but merely inviting the court to apply the traditional test to be fair, to be appropriate. Now, the partial dissent argues, they generally agree that 10J doesn't include language that overcomes that presumption, but instead, Justice Jackson looks at the context of the NLRA in general and the power and the authority that we typically confer to the NLRB to evaluate these cases and to adjudicate these cases. And she argues that the court should be a little less exacting about the likelihood of success on the merits, and a little bit more deferential to the board in its initial findings that there's a case here to be had, right? By issuing a complaint and coming to the court and asking for an injunction, the board's already saying, we've looked at this and we think that there's something here. And Justice Jackson's arguing in her dissent that the court should take that seriously, that they should defer to the board's investigation and complaint process, and not apply what is typically a very high bar for likelihood of success on the merits. When you compare this to the other types of injunctions, the example that I said before about, a dispute over property, if someone has a good faith dispute, right, they disagree with somebody about how something should happen and they can afford the filing fee, they can get into court, they can file a complaint. And the initial bar during the pleading stage of any case is relatively low to get forward. The courts are supposed to be accessible to people. But so it kind of makes sense that when a case hasn't been vetted and someone comes forward and tries to get the court to intervene and to stop someone from doing something, the judges may, want to take a good look at what the case is happening. From my perspective, I think that that's the complaint process, right? I'm persuaded by this idea that the board has already kind of put this case through the ringer and has weeded out the claims that aren't likely to be successful by taking them forward. But obviously, the Supreme Court disagrees with me. The board ended up finding that the NLRB, or rather the court ended up finding that the NLRB is not entitled to deference in these preliminary determinations, and that the NLRA does not support what they called a watered down standard. So at this point now, across the country, district courts are expected to apply this traditional 4-part test whenever the NLRB requests an injunction, a 10J injunction, which they're still allowed to do. It's now just going to be much harder for them to get because they have to meet this high standard of proving likelihood of success on the merits, likely irreparable harm, this balance of the equities test, which is going to consider, the business's need to not be enjoined during the course of the litigation and the public interest. But I guess the next question, at least for me, is why does this matter, right? So it's a big change in the law. More than 2/3 of the circuits were applying this more gentle test that the Sixth Circuit had been used, and now that's completely changed. And this, everyone's now required to do this higher standard. But what's going to be the result of that? So, the first and most obvious is that there's going to be fewer injunctions. The prior standard applied by the lower courts was highly deferential to the board. And this new standard is required by the Supreme Court will make it much more difficult for the board to get an injunction. And what this means is that during the course of an administrative proceeding, which I've already told you can last many years, the victims of unfair labor practices, these employees who were mistreated by their employer, ostensibly for engaging in what is lawful activity, protected activity, are going to be out in the cold, right? They're going to be waiting, and the practical impact is they're going to need to find work. They need to pay their bills, even if they're right, even if they were mistreated, even if they're ultimately going to be entitled to back pay in the future. That promise of back pay doesn't pay the bills now. And it's, a common saying that there's no rights without a remedy. And here, the employees have a right to engage in concerted activity. But if an employer violates those rights and terminates them for doing what they're allowed to do, it's going to be years, many years, before any sort of remedy comes down for them.
And really chilling, right? It's chilling. So then why go through that? I can imagine.
Right, exactly.
People would say it's not worth it. I'm going to walk away and forget it. And then in turn, it's chilling to anybody else who is in that, kind of that organizing campaign. I know in that case, that's what we're talking about, was an organizing campaign.
Yeah.
As to, gosh, that happened to them. Definitely, you can definitely see the chilling effect. Mm-hmm.
Yeah, I think that that's the most concerning part of it for me is, it's going to have this negative impact on the individuals who are terminated. That's awful, right? That they're going to be left without a remedy for so long. But what it's telling employers now, right, is that this is going to be a much more effective tool for them. Mm-hmm. Certainly, there's plenty of good employers out there, and we value them. But the concern is that bad employers may terminate union organizers in an effort to scare others away from the union campaign. Mm-hmm. If you're working your shift and you see a number of your coworkers get fired for speaking up and saying that they support the union and saying that they want to participate in it, saying that they're going to vote yes, and you've got bills to pay every month, you've got people to take care of in your life, you're going to be much less likely to speak up, to raise your hand, to participate, right? And I think employers know that. And so I think bad employers may use this as a way of scaring people away from the union campaign by penalizing those people who are, kind of most vocal in their support, knowing that the board can only offer a remedy far after any organizing campaign is going to be well over, right? It's going to be years before, at most, they're required to pay the person what they would have earned in the meantime. And, at that point, they can say they've already turned enough people off of the union to hopefully have won the vote. So I think that that's a real concern here, this chilling effect that it will have, and a feeling that, you're going to have union organizers or people at the NLRB telling you, well, the employer's not allowed to do that. You have these rights. It's your right to engage in this activity. But then people I think, are going to be a little disillusioned when they realize that when the rubber hits the road, they may not have, the substantive protections of the law that they think they do, right? And the other thing that I think is interesting about this case is, I think it's a worrying sign of what might be coming down the road. The current Supreme Court has been working to limit the deference shown to administrative agencies across a number of cases over the last several years. There's been cases involving other agencies like the Environmental Protection Agency and others that have curtailed their ability to do their job. This case explicitly limits any deference provided to the NLRB during these preliminary matters. And then, in the same term, so last June, the Supreme Court also issued a decision overturning a case that's referred to as Chevron from many years ago, which required courts to defer to agency determinations in certain situations. So that was, a much bigger attack on the deference that's shown by courts to the administrative agencies. I think that there's still some question about how that will apply specifically to the NLRB. There's been at least one court case since then that has found support for deference to the board in other lines of cases. But, we're not sure that that's going to hold up. So we'll have to see, that becomes even harder, I think, for the board to enforce the act if all of their decisions are, kind of reevaluated by the courts without any deference to their expertise or their ability to investigate and enforce the act as they know it. So in that way, this case is very concerning, and it is in part limited to a small change in the procedure for getting an injunction. One aspect, the board still has all of its full powers to pursue a ULP and to go through the administrative proceeding and to issue strong awards with remedies for the members, eventually. So I don't want to blow it out of proportion, but at the same time, it does seem in some ways concerning about how the courts are going to be treating decisions by the board and the board's kind of authority to move forward and enforce the act.
That's why sometimes when you see these cases come out and it's like, wait a minute, what? Like that little piece of it, but yet there's implications to it. So let's talk about kind of the National Labor Relations Board. So today is January 28th, 2025.
Yeah.
I'm looking at the date here just to make sure, 2025. There's been a little bit of, I guess I would say, little bit of update about the National Labor Relations Board. And if you kind of fill folks in on kind of where we're today, things change by the moment. What it means.
Yeah, where we are now, as we film, as they say. So leading into this year, at the end of last year, we already saw that the Senate failed to reconfirm Member McFerrin to a new term. So her term was scheduled to end in December. She wasn't reconfirmed. And so we went into 2025 with 2 vacancies on the 5-person board. So we had 3 members sitting on the board and 2 vacancies. Just yesterday, on January 27th, President Trump took 2 additional actions against the board and the agency. One was somewhat expected. President Trump fired General Counsel Jennifer Abruzzo, who held her role since 2021. The general counsel was active in her role by enforcing the act and trying to meet problems within the workplace head on. Her termination certainly creates some uncertainty about how the agency will move forward and the current authority that the agency has to act in the short term without a general counsel sitting at its head. But this is something, while previously somewhat unprecedented, President Biden took similar steps when he entered office in 2021, and I think most people expected President Trump to take this action shortly after taking office. But the second thing that President Trump did yesterday was truly unprecedented, and I think caught a lot of people by surprise, at least it caught myself by surprise. President Trump fired board member Gwen Wilcox. Member Wilcox's term was not scheduled to expire until August of 2028. The law limits the president's power to remove board members, and so Member Wilcox will almost certainly challenge her termination. I saw a statement from her today saying that she was going to challenge it. I think the White House has put out some sort of release that they had cause, though that doesn't really line up with the standard that's in the law to begin with, and doesn't have any substance to it. It's hard to believe. But by firing Member Wilcox, it leaves the board without a quorum. So we're now down to 2 members on the board instead of 5. A case from the last time this happened, a short while ago, held that decisions by a 2-member board were invalid. The case is called New Process Steel. So in that case, eventually the board developed a quorum, and the full board approved much of the work that the 2-member board had done. The 2-member board they weren't being able to get a 3rd member appointed, and so they continued on, and wherever they could agree, so in theory they had 2 out of 3 votes, they would act. All of those decisions were eventually found to be invalid, but the full board quickly just did, kind of approved all of the cases, all of the work that they'd done. There's no guarantee that that's going to happen next time, right? So I think that there's a lot of uncertainty now about how the board moves forward from here. When President Trump will appoint any new members to give it a quorum to act at all, and what authority the agency side has without a general counsel. So this is obviously very new. We're still waiting to see how it happens.
Right.
But it's certainly a time of uncertainty at the moment.
And again, chilling. So if you have a ULP, would you file the ULP?
Right.
Because you don't know where it's going to be, and it's
Right.
very chilling. It's just very chilling.
There's cases in the pipeline that now just halt. Right. Yeah.
Right. Exactly. Oh boy. Well, I want to thank you so much.
Oh yeah, absolutely.
Taking us through, because we read these things and it's like, my goodness, what?
Yeah.
and helping us put it into some perspective, and kind of where we are right as of January 28th, 2025. I'm sure we'll have it back on as things develop. But
things will continue to change. Yeah.
Yeah, this is one piece of it that it's like I work for the Massachusetts Nurses Association, so I think we have some cases in the pipeline. I'm sure other unions do as well, as to kind of what happens to the cases that were already filed, kind of where are we? Concerning, but we'll keep on the lookout. Anything else you want to add?
No, I think that's what I came to say. Thank you so much for having me. Again, I so much enjoy the work that I'm able to do with the Guild, and being able to watch the other work that you guys do. I think it's great.
Thank you very much. And I want to thank all of you for watching. And I also want to thank Liam for being our tech support. So thank you very much.
Wouldn't happen without him.
Exactly. Thank you.
If you are interested in learning more about the world of labor and management relations, you can find more information through the Labor Guild's video series or enrolling in the Guild's School of Labor Management Relations. Courses are offered online as well as in person and are taught by experienced labor and management professionals and neutrals. For more information, visit the Labor Guild website.